The unique thing about these cases is if he doesn't pay his restitution while he's on probation, again, that's a crime. Good morning, Your Honor. Did you call the Newell case?
No, sir. We're getting ready to, though.
Thank you, Judge.
All right. He's making his way. Our next case this morning is People of the State of Michigan versus Blake Newell. This is file number 24-13924FH. Appearances, please begin with the Assistant Attorney General.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the people.
Robert Hartzell from Mr. Newell, who joins me at the table.
Thank you. Mr. Newell is here. You may be seated. Also before the court this morning is Mr. Sean Van Atmel. He's the agent from the Michigan Department of Corrections. In charge of the file today. Looks like Mr. Potter may have been on it one time, but actually so was Mr. Van Atmel back when the case was placed on the delay. All right. First of all, we'll take a look here and go over the new SIR K8 and the 145 and the 101. Mr. Wood, have you received a copy of the updated PSI? And if so, do you have any amendments, corrections, or objections to make to the content?
Judge, I have a change to be made to the restitution provision, and I don't think it's in the nature of allocution. I believe it's a change that needs to be made. Paragraph 15 of the recommendations, Your Honor.
Yes, sir.
It simply says you must pay child support and related expenses as ordered by the court. That's a phrase that has been passed down from MDOCs on these cases, so that's what most of the agents say, but it's not as complete as it needs to be. It should say you must pay ongoing child support and arrearages in the amount of $17,096.39. That's the current arrears. And then a sentence after the sentence that's there right now that says ongoing child support and arrearages must be paid through the Wexford County Friend of the Court or the Michigan State Disbursement Unit.
Mr. Van Atmel, can you make those changes? Thank you. I think we also, and I'll turn back to Mr. Wood in just a second. I think we were originally scheduled back on November 10th, so we have to change the CFJ 145 page 1 to today's date, which of course is November 24th. All right, Mr. Wood, we're with you. Anything further that you believe needs to be amended or corrected?
Not at this point, Your Honor. No.
All right, thank you. One moment. All right,
Judge.
Mr. Oh,
Judge, I apologize. Again, these are. I think it's a change that needs to be made, not just a allocution, but Judge, the liabilities section near the end of the report says there are no liabilities, and I mean that's all this case
obviously
is about.
that does not. Yeah. Yes.
His liabilities. So his liabilities are ongoing child support in the amount of $310 per month. And again, a child support arrearage in the amount of $17,096.39. So that's what I would like the liability section to say.
Oh, all right, thank you. Mr. Van Atmel can make that change. Which section are we looking at? Is that back in the old part? Because I don't know
yes,
if we covered that. Yeah, it would be back in the previous PSI because the update doesn't deal with that. That would have to be probably CFJ 284. Hold on.
Yes.
Mr. Van Atmel.
Page 10.
All right, there we go. All right. So underneath finances on CFJ 284, page 10 of the previous PSI that was issued back on November 7th of 2004, we're just going to add that there are liabilities. Granted, it's already listed underneath the liability narrative, but we can address that. All right, thank you. All right, Mr. Hartell, any other amendments, corrections, or objections to make to the content of the report?
No, Your Honor.
All right, one second. want to make sure I understood the kilobrew.
The killer brew was for a delayed sentence, Judge, and
Yep.
he didn't meet the threshold for a reduction, so he's got the 2 counts of felony non-support. There's no killer brew beyond that as to what we would ask for at this point.
I got it. I'm getting it. All right. Thank you very much. So now I'll turn to allocution to the defense. Go ahead, Mr. Hartel.
Thank you, Your Honor. I would ask the court to consider this being a situation where there is no additional jail or probation. I believe that would be appropriate under the circumstances. My client, albeit has not met the threshold to get the benefit of the delay of sentence, but at least some payments were made. He does realize this debt, which is the best way I can think of to describe it, will continue. He will continue to owe the child support and the outstanding court costs. If he fails to do so, well, he'll be staying at the local county lodgings. And he is aware that these don't just go away. People do have arrears into the future. He's also, I'll even use this phrase, painfully aware that he's going to have the label of being a felon as a result of this conviction. Is going to influence him in all the ways that influences everyone else. Finding work was difficult before. It's going to be even more difficult for him. He's not going to be able to do the same level of hunting he used to enjoy, things of that nature. I do believe those punishments and the fact that this will continue to be owed are sufficient without any additional punishment. Thank you, Your Honor.
All right, Mr. Wood, allocution, sir.
Well, Judge, I know the recommendation is for straight probation, and you know, if Mr. Newell had been paying, I know as and it's correct that he's made some payments, but he's missed most months. I mean, since the initial sentencing back in December of last year, his $4,200 bond had already been paid in. And so that's in again December. He paid nothing, and I understand he's a cement contractor. That's our understanding, is that he has a business and he's only 36 years old. He's an able-bodied man by all accounts. But he paid nothing in January, February, March. In April, he paid $600. He paid nothing in May, nothing in June. In July, in the heart of his season, he paid $1,200, but he paid nothing in August, nothing in September, nothing in October, and nothing so far in November. It's unacceptable, Judge. He's got a 6-year-old child here that he's going to have to take care of for a long time. And he did pay his bond, so he got the benefit of the delayed sentence, but he did not do well during the delay, Judge. I'm thinking, Judge, I'm thinking it's the Monday before Thanksgiving. And I'm thinking that Mr. Newell maybe needs to spend the next period of time that you can choose in the Wexford County Jail. And he needs to be on probation. We're going to ask for 3 years. I know normally I'd ask for 5 years. I don't think that's permissible anymore. I don't know the exact requirements, but 3 years of probation. And again, some initial upfront jail, so he understands that this is serious and he needs to comply with the court's orders. But
can I give him jail on a felony on a felony non-support with an intermediate sanction scoring of 0 to 9 months?
Sure you can, Judge. I mean, he basically committed several felonies while he was on your delayed sentence. Yeah, each month he didn't pay is another felony. And yeah, there's no prohibition. Maybe probation can pipe in about this. No, you can give him upfront jail.
Yeah. So, but what would you suppose my reasonable grounds be?
Because he's committed felonies while he was on a delayed sentence, and he did not comply with the underlying child support order. Judge, I don't think there'd be any problem with you imposing, again, I would suggest 7 days of jail starting now. And, so he doesn't wait till after Thanksgiving. And then again, this is a 6-year-old child that he's got to take care of for a long time, Your Honor.
Let me go back and address one of those comments. What was the felony that he committed while he was on a delay?
Well, Judge, I know it's the felony non-support statute, MCL 750.165 says, so that's the felonies he's committed, Judge. Each month he didn't pay. That's another felony. And again, we don't think of it that way, but yeah.
It was the way you said it. I thought maybe there was a felony that committed that I missed, but there hasn't been any new convictions while he's correct?
No new convictions.
Yeah. So, all right. So on the felony non-support, 1 second. So. To ask a question. 1 second. There we go. Sorry. So what I'm looking for is what are my reasonable grounds that would I can use today to go and rebut the reasonable presumption that he is to get probation and fines and costs only. Is there an exception for that on child support, or because typically there's an exception for crimes that are violent, like domestic violence, assault, battery, and so forth. So that's why I was looking. I was concerned. I think it's 771.34, or no, 769.31B. That's what I wanted. Is there an exception to that? 769.31B that should have some exceptions. So I have to have reasonable grounds to be able to give somebody any kind of confinement. And so far as I understand it, underneath that section, I have not allowed to unless there is a certain exception. So that's my problem here.
I'm looking at 769.31B. Oh, this is 31.
Yeah. And then it's into 34. So 769.34 takes me to where an intermediate sanction must be imposed unless I have reasonable grounds. And I need to know, that's why I'm asking, what are my reasonable grounds? Now, there can be some exceptions here for violent crimes without finding reasonable grounds. But the problem here is it's an intermediate sanction. Those in Lansing have told me, which includes the entire legislature, because it was almost overwhelmingly voted for by everyone back in 2020. I say everyone that held a legislative position and the governor told me that when there's an intermediate sanction, I am not to give jail unless I find reasonable grounds. Now, that makes it troublesome, and sometimes it makes it troublesome for me. And say a child support case, or actually even a variety of cases, let's say it's an embezzlement from a car dealership.
Right.
I don't have somebody from a victim coming in and saying, Judge, this is really, really hard because it impacted me because we couldn't pay wages, we couldn't pay salaries. Or here, if I had something, and by the way, I looked, there's no victim impact statement. If the victim had said, hey, I can't afford to pay for soccer games, or I can't afford to feed the child, then I'd have some kind of reasonable grounds. When I look here in the past, I don't see that. I see the defendant has been on, he's had a couple dismissals. I will say he had one case where he had a probation violation back in 2007. So I need to have some reasonable grounds, and I don't really know what they are, especially without a victim like a wife or the mother of the child being here.
I have to be honest with you, Judge. I've done a whole lot of these hearings. This is what when I retired from the division, from the AG's office, I was running this division.
Yeah.
And
trust me, I want to place a parent who is not taking care of their child. But this, I don't know when you were last in charge of this division,
right.
but 76934 became law back in 2020, took effect on March 24th of 2021. And this law says that when there's an intermediate sanction, such as in this case, I am not allowed to give any jail unless I'm able to find reasonable grounds. Now, when I find reasonable grounds, I can't take into consideration anything that was already used to reach the scoring, which means I can't take in his prior criminal history. I can't take into consideration the amount of money. I can't take into consideration the fact that he's got 2 convictions at the same time, because all those things are taken into consideration for finding reasonable grounds. And personally, I may not like this statute or how it ties the hands of the court, but so far it also hasn't been reversed or challenged in the Court of Appeals yet. So I need to know, I'm looking if is there a separate exception that applies to these kinds of offenses? That's what I really need to know. So,
Well, Judge, if the law doesn't allow you to, again, while someone's on a delayed sentence, which is it's a matter of grace from the court, I can ask for it. You don't have to give it. I don't have to ask for it. You can give it anyway. We asked for it. You placed him on the delayed sentence, and then during the delay, he flaunted the court's order. I mean, he again violated the underlying child support order, and he committed, again, I could count them up. I think it's 7 or 8, maybe 8 or 9, because the way the law is written, when this project started a long time ago, back in the early 2010s, the AG tried to get the law modified so that there was a tiered, maybe a $0 to $1,000 in arrears is not a crime yet. Maybe 1 to 5 is a 93-day misdemeanor. 5,000 to 10,000 is a low, high court misdemeanor, that sort of thing. The legislature did not want to do that. Instead, the way the law reads is that each month that a person doesn't pay child support, a day late or $1 short, is a new crime, is a felony. Yeah. And so he's on a delayed sentence that you placed him on. And during the delay, he commits 7 felonies. And I know he hasn't been convicted, but I don't hear any argument that he did pay. No, I was paying, they just didn't know it.
I got it. So Mr. Wood, you are preaching to the choir. Here's another thing. Can I give somebody jail when they fail to pay fines and costs on probation?
Again, you have somebody from MDOC sitting there, and I understand that if there, there's a distinction between a technical violation and a non-technical violation.
I know, but if somebody violates by not paying their fines and costs on probation, let's say he wasn't on a delay. Am I allowed to put somebody in jail merely when they're unable to pay unless somebody proves to me that he has the ability and chooses not? That's the key language.
Right.
The point
I'm
here-
familiar with
yeah,
that concept, Judge.
yeah,
Absolutely.
So,
Yeah.
so
Now, the
here's,
unique
here's
thing
my,
about
go ahead, sir.
the unique thing about these cases is if he doesn't pay his restitution while he's on probation, again, that's a crime. And
Yeah.
so, whereas normally not paying restitution, although again, there is still the provision where we've got to show that that he does have the ability, or it may be that he's got to show that he doesn't have the ability. That would make more sense. I know we've done some hearings like that.
Yeah, Mr. Wood, I completely agree. Everything you're saying makes so much sense, but the legislature and with the approval of the governor have told me that what you and I think makes sense is the law. There has to be proof that the defendant could afford to pay and chooses not to. Or I have to have reasonable grounds. And when I get to these hearings, by the way, prosecutors rarely ever bring in witnesses to tell me, here are the reasonable grounds, such as not having this money means I couldn't pay for this, I couldn't pay for that. I can tell you, I want to put deadbeat parents in jail. But I need to have the legal authority to do so.
Judge, if the victim was there, how does that, where does that, I apologize, Judge, but where does that fit into the, you now have a reasonable basis?
You'll note that I began this conversation, and by the way, I'm doing this intentionally for a couple of reasons. But I first began by asking the question, where is the authority that allows me to do it? And unfortunately, there really isn't. Because 769.34 tells me I can't unless I have reasonable grounds, which means until someone presents something to me that allows me to find reasonable grounds, because there's another court rule, there's another statute here, and I think it's probably the 769.31, where if I find that the guidelines are inadequate, and that's the problem. This is one of those things where whoever enacted the statute may or may not have known what they're doing, but I assume they do. That's what the law tells me. I'm supposed to believe that they do. It says that I can find that the guidelines are inadequate and don't account for it. I could use that for reasonable grounds, but so far it's not presented to me. That's my problem. So, all right, here we go. All right, sir, Mr. Newell, you have the right to make a statement before the court issues a sentence. Is there anything you wish to add today, sir?
Yes, sir.
Yes, sir, go right ahead.
First of all, I apologize for what's going on here, and I've tried the best I could for the whole year on this probation thing. It's just been a struggle for me, and I'd like to, Mr. Woods here said that I paid in July $1,200, and I'd like to, it was $1,250. And each payment that I made was over $500. I understand that I have a $310 payment each month, but I simply couldn't make them. Life's a struggle right now for me, and I'd like to apologize. I'm sorry. Thank you.
All right. Court sentences the defendant as follows. The court places the defendant upon a period of probation for 36 months. I adopt the terms or conditions that are listed in the pre-sentence investigation report on CFJ 145. page 2, continuing on to page 3. That includes the added change to the language on paragraph 15, which is term or condition 9 or 8.9. That is, the defendant is to continue to pay his ongoing child support and paying on the arrears, which are $17,090. I think they were $96.39. The defendant has the right to be considered for early release on probation at halftime if he's been compliant with those terms and conditions. I don't know here whether or not, I think all the terms and conditions are probably appropriate. Let me take a look here at the defendant's criminal history. Yeah. Court wants to ensure that the defendant is not using any kind of substances, but the random the testing is only if required by by the probation officer. The court is concerned though, because if there is an alcohol or substance use issue, whether it's marijuana or alcohol, the court wants to ensure the defendant is clear-headed so he's not missing it. Now, there's probably one thing here. Hold on, let me go through the fines and costs. So we had $268 state minimum fees, the $130 crime victim right front fee. I'm going to do the $300 court cost. I'm going to keep the fine at 0. The attorney fee again is $300. We probably did not need a DNA fee here. $30 is supervision per month, or $60 if there's any electronic monitoring. The big question here is what, if anything, can the court do for sentencing as far as any jail time? Well, I was looking for the argument. No one was able to provide it. At least nothing that really helps me understand this. How old, what year was the child born in? Does anybody want to tell me? 6 years ago? All right. So, is it just one? Yes. Okay. So,
Off and on, so work's been slow.
okay. Mr. Wood, I'm going to tell you, these rules and these statutes do not make sense when and this is what I'm trying to do today. I'm trying to highlight, at least as part of this 3-branch government as a judicial officer, maybe you as part of work, go and deal with this yourself. But I can't use anything because no one's given me anything yet. By the way, if prosecutors were to decide to start showing up and presenting to me some more victim impact statements, maybe I could. So I give the defendant his 15 days in jail with 15 days of credit. Do I think a person who takes care of the child, should he or she go to jail? Yeah. But the legislature has told me that I can't, unless I have reasonable grounds. And I find that the guidelines are inadequate. So far, I have nothing that's objective. My only decision would have to be subjective. And I can't do that as a judge. That's not within my realm. I'm supposed to be, and I am, neutral when I'm sitting here. So anyways, all right, that is the sentence of the court.
Yeah. Delay, the fine, attorney fee, and court costs were $100. Did you want to increase to 300 or leave them?
No, thank you very much. I'll just leave them because I really want him to be able to pay these fees off. I'm sorry, the child support. Thank you very much, Madam Clerk. So I've adjusted those amounts. All right. Trust me, Mr. Wood, you and I agree.
Well,
But
Judge,
Jason,
I greatly appreciate the time you've taken to go through this process because this is going to go up the chain of command here. Because
Yeah.
I'm a little,
Perplexed.
say embarrassed that I know there's restrictions, but when someone commits a felony, that should certainly be an exception. And there should be exceptions. So I will look into this, Your Honor, and I greatly appreciate your time. And Mr. Newell should know that what the AG can do is if he doesn't pay going forward, they can charge him again with felony non-support. If he isn't paying at least his ongoing support, that's a crime. And that's what the AG does with this in this division. So he needs to start paying his ongoing support at least.
I understand. Again, today, while two people may agree, I'm not a person, I'm a judge. So, Mr. Newell, you are receiving 2 copies of one document. You will place your initials on one copy. Doing so neither elects nor waives any rights. It merely acknowledges receipt of your copy of that document. This document tells you that you have the right to appeal the conviction and sentence in your case, and is typically done by filing what's called a claim of right to appeal. However, when there's a plea, the plea that reduces it down to you can only file what's called an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half and return to the court within 42 days. Do you understand, sir? All right, Mr. Newell, I know we've been talking around you a lot today. This is about you as a father. You got a kid out there who needs you. Maybe it's just money, I don't know, but let's focus on that. I know you're having a difficult time. I hope that you're taking jobs, even if it's something that's like you might think is below you, because when you're a father, nothing is below you. I don't care if it's picking up trash, working in a Christmas tree field, or picking fruits or vegetables someplace, or working in a yard.
Well, I've applied at a couple jobs recently within the last 2 weeks, just because I know it's get towards winter and it's gonna be no work for me, you know what I mean?
Yeah.
So, just so you know, I'm trying.
Mr. Newell, keep it up. Keep it up. Work hard, okay? Thank you very much. We are adjourned.
Thank you, Your Honor. Thank you, Mr. Hartel.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.